Hello and welcome back to another episode of Fully Booked, the Hidden Gems author podcast, in which Craig Touch and myself, Roland Hume, chat to some interesting figures and leading lights of this crazy industry of writing and self-publishing. And today we are very, very pleased to have a special guest, Peter Nieves, who is an attorney, public speaker, and an author, here to talk to us all about intellectual property, all the stuff that, I don't know, the technical stuff that we doesn't get talked about very often. So Peter, we're delighted to have you here today. How are you doing?
I'm doing great. Thank you, Roland, for the introduction. And it's great to be here with you guys.
Oh, well, we are delighted to have you, and we're delighted to pick your brains as well. And of course, we wouldn't be without the man himself, Craig Touch, the owner and founder of Hidden Gems and an author himself. How are you doing today, Craig?
Great, thanks, Roland, and thanks for joining us, Peter. Peter and I were we were fellow panelists on the online AI author summit that was run in April 2024 for InfoStack ran that. So we were part of a panel about the future of AI, and it was a really interesting panel. A lot of Peter had a lot of really good points about how IP and AI sort of interact and intersect, and what it means to use AI in terms of intellectual property law. So that's why I wanted to have him on, because the panel was about a whole bunch of different topics. We were all talking, but I wanted to, it was so interesting to me that I wanted to get him on so that we could really just focus in on this topic specifically. So thanks for joining us, Peter. And why don't you tell us a little bit about your background and what you do, and then we'll jump into it.
Sure, absolutely. So I've been an IP attorney for 25 years. I handle patents, trademarks, copyrights, trade secrets, AI law. I've been an adjunct professor of IP law for quite some time. I've run different challenges, networking events, so as to train the public on legal information that they just don't get access to. I mean, imagine running a company and then having to rely upon legal information from an Instagram app, or from like YouTube or from TikTok. And that's how people are running businesses. It's really scary. And so I left a large New England law firm running their IP department. I actually started their patent law department 18 years ago. And I decided to run my own law firm and build an educational institution. And that's what I do. I do this. I train people on information they just don't really have that's not really readily accessible to them. And more importantly, they don't know if it's accurate. Because I've seen influencers telling people to do things that are illegal, and they have millions of followers. As an example, I saw an influencer telling people to copy Russell Bronson's funnel, how to copy the URL, throw it into a new AI program, scrape the information and throw it into ClickFunnels, and you literally have his funnel, his $1 million funnel. That's called copyright infringement. And he's telling millions of people to do this. And people in the chat are excited. And I'm going, oh my gosh, this is why I'm busy. Because of things like this. So we decided to just bring the knowledge to the public. And it's so rewarding. We love it. People's lives are being changed. So this is a much better way of doing business.
It's a very interesting time right now in terms of the whole concept of intellectual property, because it used to be you wrote a book and that was your book, and if someone stole it, but these days they're like memes, and memes by the whole thing are shared. I mean, I think the name meme, Richard Dawkins came up with it because it rhymed with gene, because it's something that evolves over time, and it's like memes are just one thing that people share, that there probably is intellectual property behind it.
Yeah, I mean, often what people do is they grab a little bit of somebody else's statement, book, their published work, and they throw it into their own context with an image, and all of a sudden the thing goes viral, and it's really somebody else's content. It's really somebody else's image. And with AI, you're seeing it even more, because now you can have it automatically done. It's amazing how fast you can create ads and marketing material. Within 5 seconds, you could have an entire plan done. But the problem is that a lot of that content's scraping other people's copyrighted work. And so you've got to know what the resources are, or where's the data coming from that's in the database that's being utilized to create what you want that you're then going to use for marketing. And if you're doing that responsibly, then AI is phenomenal. If you're doing that irresponsibly, you're you're walking on a field with landmines all over the place, just waiting for something bad to happen. And unfortunately, people are just not aware. So we're bringing awareness to this. That's why I'm glad you guys are doing this now.
Yeah, I think that that's one of the problems is people don't understand the nuances of the law. You know, something like memes, I think the idea is, oh, well, it's okay because it's fair use, right? So people know the term fair use. They don't necessarily know what it means. They just know it probably applies here. So I think that that's one of the problems, right? So, you know, in terms of memes and fair use, is that covered by sort of fair use?
That's a great question. I love that you start out with this question, because a lot of people, what they do is they say, oh, I'm just grabbing a little bit of content. It's fair use. Yeah, no. So the way I look at fair use is it's like your mother told you can't eat a cookie before dinner. Now you've got your hand in the jar and you're grabbing a cookie, and now you got to come up with an excuse for why you're violating what your mother told you to do. Like that's what fair use is. You're essentially committing copyright infringement, and you need an excuse to say, well, no, it's really not copyright infringement. So just if you think of it that way, maybe you'll be more conscious about what I'm doing. So there's like 4 main elements in fair use. Like one of the biggest one is like, what's the contents of the information that you're taking? Is it like newsworthy information, or is it content that is like fictional storyline information? If it's more like newsworthy, then when somebody takes a small portion of something that's like newsworthy, there's a higher chance that it falls into fair use. Now, then you're looking at how much of the content are you taking? Are you taking like the essence of the copyrighted work, or are you just taking like a small portion? If it's a smaller portion, then you have a higher chance that it's fair use. Then on top of that, you look at what kind of damage does it do to the original copyright owner. Like if you're taking the essence of their copyrighted work and you're throwing it into your work and saying fair use, yeah, no, courts are not going to say that's fair use. So and there's another element as well, so I could go even deeper, but the main point is how much are you taking? What's the context of it? What's the effect on the other party? Those are the main components. And there's another one too that goes even deeper. But the whole point is, if let's say the Twin Towers just had an airplane crash into it, and you saw that on the New York Times, and you take a blurb from the New York Times and say, hey, this just happened. This is a blurb from the New York Times, right? That, if you're not charging people for it, and it's in an information environment, educational environment, and it's not the essence of their work, and it doesn't have some kind of financial detriment to them, that can be argued to be fair use. Because so it's a very measured area. So we have to fall away from this idea of, oh, everything's fair use. I'm just grabbing a little bit. And here's the other part that's really bad, Craig, is that a lot of people take someone else's quote and say, well, I gave them attribution, so that means it's fine. Like, you know, here's the image from this artist in my book. That's created by such and such. That's copyright infringement. Now, in grade school, you could copy somebody's stuff and give attribution, right? And so you get away with not plagiarizing somebody's work. But I'm not talking about plagiarism. We're talking about copyright infringement. They're not the same thing. There's a big difference between, I can get away with grabbing somebody's content and giving them attribution, not be sued for plagiarism, or not get in trouble with the law school or with college for plagiarism, but I could still be sued for copyright infringement. So there's a big difference between the two, and you have to understand the difference.
I think when it comes to memes as well, people use the argument of parody, right? Especially when they're using sort of the images. And that's another thing that they think covers them. Well, you know, it's not a problem because it's just parody, you know?
Yeah, and in some cases they are. In some cases they truly are. Like, you know, you take some kind of event and you put it in a funny way, poking fun at the original work, and that's actually a means of expression that is protectable. Like, right. You're okay with doing that. Just make sure you're looking at the law, because I can tell you as a fact, Disney sues tons of people for their parodies off of their movies, off of their scripts, off of their books. Somebody claims that it's a parody when it really doesn't fall into the category of parody. So you have to look at what are the elements. This is why truly understanding legally what is fair use, what is parody. Do I fall into that area? Yes, awesome. Go at it. Make money, have fun, have a great time. But if you don't do it right, you can get into a lot of trouble.
Yeah, for sure. And you mentioned plagiarism, and that's another issue, especially around AI, that I think is a little bit confused with copyright and intellectual property and stuff. So what I hear from authors sometimes is, well, they don't want to use AI because, or they don't agree with AI because it plagiarizes. And I don't think that that's the case. I mean, you can make AI plagiarize. I could say, give me the first paragraph of War and Peace, and it'll spit it out, right? But that's a whole separate thing. That's me asking the AI to specifically do some data retrieval and grab a piece of information. It's not me saying generate a story and then maybe I describe War and Peace to it and then it spits out that first paragraph. It'll never do that, right? Because that's not the way generative AI works. It's building
extremely
word by
rare.
word. Yeah, I mean, it's the million monkeys thing, right? Yeah, it could happen in a million years in a million different iterations, right? But it's not going to. So, yeah, I think that's one of those areas where people are a little bit confused as well.
Plagiarism using artificial intelligence, generative AI, which is utilizing neural networks and learning from information that's being entered to learn patterns and to come out with the right information to give you based on previously inputted data. The chances of you getting something that's plagiarized is low, but you can still definitely run into copyright infringement because the essence of somebody's work most certainly can be provided as a result. And I've run tests on this. I've actually asked it to give me the next chapter in a book, specifically, and it's given me and created a next chapter in a book that's utilizing a large portion of the book itself, which can run into copyright infringement. So you have to be careful as to what's the source and how effective is this AI bot essentially in giving you the results. So you do have to be cautious with copyright infringement issues because it's scraping information, and that's the essence of the New York Times lawsuit. New York Times versus Microsoft and OpenAI, and one of my best friends is legal counsel for Microsoft, and obviously he doesn't give me the confidential information on what's going on in the case, but I can tell you that it's a very big deal that all these things that are being subscribed to by others, these news publications, these articles, these books, are all within the database for OpenAI, and that information is being utilized to give results. And so if the essence of a copyrighted work is provided as a result of your typing in a specific prompt, you can run into copyright infringement issues. And so this is going to get fleshed out a lot in the federal district court right now. So they're already analyzing this, so you're going to see more on it. But for plagiarism, that I find difficult because you're talking word for word, like the exact same words. And that's
AI is not even going to give you the same response if you put in the same prompt over and over and over again. It's still not going to give you it. It can give you a vastly different one because it's building each word based on the last word, and there's a degree of randomness added to that. So
by its very nature,
it's so. Speaking of that and other lawsuits, I want to talk about that because I have some questions around what is in essence, what are they arguing? What is the New York Times or anyone who is sort of suing these big AI companies? What is their argument? Because what I hear from authors, saying that the problem is, or what I hear from when I see in the news, or what I see from my understanding of those lawsuits, sometimes they're not aligned. I think there's a lot of things that are getting sort of mixed up here. So I'd like to, from you, who's the expert, hear about like what it is in layman's terms, I guess, what it is that that the New York Times is essentially suing them about.
Right. So this is interesting because it's being further developed. So as a litigator myself, I can tell you that you can file a complaint with the court that actually lays out all of your cause of action, what the other party's doing, what you believe is infringement, the basis of your lawsuit, and it can be further developed as the litigation proceeds, right? So this thing is being further developed. But I can tell you This was a very long complaint, quite verbose, many words. Somebody paid a lot of money for that complaint. Let's put it that way. And it goes into the history between the New York Times and negotiations with Microsoft and OpenAI before the lawsuit was filed. And in fact, a year before they filed a lawsuit, they were in negotiations trying to figure this out, because what OpenAI did was obviously they scraped the internet. So anything that was quote unquote published and quote unquote publicly available was garnished in their scraping process from the internet and placed into their database, right? That's how it built its database. Well, in that process, what it included the scraping of, I don't know if it's millions, but I know it's like hundreds of thousands of articles from the New York Times, because those things were on their websites, on other sites, with copyright notices saying you can't copy this content. And along comes this engine and just grabs it all and then puts it into their database. So the New York Times is a subscription-based business, right? So they make money based on myself, you, other people subscribing to them, and then gaining access to their new publications, the new articles, the news, right? That's how they make their money. But they also have multiple tiers of access. So they have stuff that will be public, stuff that is more, you need a higher level of access. They have books, they have videos, they have tons and tons of stuff. But that's the entire basis of their business, is newsworthy content that they're spending a lot of time to create that finally gets published. Well, along comes another party and they now have access to it. So now I can type in a prompt and gain access to articles that are provided, or the content of the articles, because it's within their database. I may not be able to say, give me, well, maybe you can type in, give me the New York Times, blah, blah, blah article on such and such date. With some engines, you may be able to get the exact results, but most people aren't searching that way. But the whole point of the lawsuit is you grabbed our content, which is subscription based, and thereby made it so people are less likely to subscribe to us because they don't need us. Like, they can get access to what the New York Times is saying about a specific thing without subscribing to us. So that takes money from our pockets. We want to be reimbursed because those are people that would have been paying us. And since you grab content from us, that's copyright infringement. And with copyright infringement, I should be getting a license. So they were negotiating with Microsoft and OpenAI way before they filed a lawsuit to try to get a license agreement in place, right? And unfortunately, they couldn't come to terms because they're a subscription-based business. So the result is they said, all right, this isn't working. We need to file a lawsuit against these guys because they're not taking us seriously. And so that's where we are now.
How is that
so
even going to end? I mean, that's just such a monster. Like, everything that their model is built on includes that. You can't just like suck it out, can you?
Yeah, and here's the biggest issue about this. There's multiple issues about this. Samsung reached out to OpenAI like over a year ago when two of their engineers, there were actually three engineers that did this, but two of them made the biggest faux pas, which is they took confidential source code of Samsung, uploaded it into ChatGPT, and actually asked it to fix the source code because there were some issues. The program fixes the source code, but the problem is that trade secret was now within their database, which means someone else could actually gain access to the source code with the right prompt. And the founder of OpenAI even said this. They came out and said, do not enter anything confidential into our system because the public can gain access to it with the right prompt. And we actually make it accessible to third parties, the content for what you're adding. So never enter in a trade secret. He came out and said that. Well, unfortunately, Samsung could, not only did they disclose it and lost a trade secret worth tons of money, but they couldn't retrieve the data. Once it's in, you can't get it out. It's kind of like putting garlic in sauce. The oils are into the sauce. You can pull out the clove, but the oils are in there. So if you're allergic to garlic, you're done. And so this is why in other countries, they believe it's a violation of the DARPA rules, meaning, Data Privacy Act where I can enter something in, I should be able to pull it out. If I can't pull it out, that means it's a violate. They believe it's a violation of DARPA rules. And so to bring this back home, what the New York Times is saying is, hey, my content went in. You're saying you can't pull it out. That means you owe me royalties and you owe me damages for this stuff being stolen. Now, if they win, that's going to have a detrimental effect on all AI platforms, because most AI platforms are working through scraping. Now, there are some that are not. Like if you look at Adobe Firefly, that's all licensed and open source content of their own. So if you use their platform, you don't really need to be worried about trademark infringement, copyright infringement, because they're giving you a license to their own content. They're not going to sue you for using their content. So that means that the user needs to be responsible enough to figure out what's the source of the data that's within the system that I'm using, so that I don't potentially run into a legal issue, or do a trademark search or a copyright search after getting something that's important. So you have to figure that out. But the effect of this case is huge.
Can I just say, I loved the garlic metaphor. Like, as a lawyer, hearing a lawyer explain something using the metaphor of garlic was beautiful.
Oh, it's wonderful. No, one of the things I love to do is to make the law simple to understand. And that's one of the biggest problems in the legal industry is the law is supposed to serve the public. The problem is the public has no clue what it means. And so we need to simplify this. It's not really that difficult, but we use a lot of legal language that makes it very difficult to understand.
ChatGPT is pretty good at simplifying, but just saying. Okay, so there's a few things that I want to unpack there, but the first question I have is, when you mentioned the New York Times lawsuit, did they scrape the public-facing information only, or did they use their own subscription to then pull those tiered articles too?
That's a great question, and that's something that's going to be fleshed out in litigation. Because after you file a complaint, a response is filed to that, right? It's called an answer. So the other party files an answer saying, okay, this is allegation number 1, allegation number 2, allegation number 3. These are the facts that are being alleged. The other party comes out and says, yes, that's true, or no, that's not true, right? And then the litigation will flesh out the details. So I think what you're going to find is the very point that you're making, or the question that you're asking, is going to be subject to evidentiary hearings and proof within a court of law as to whether or not this is true or not. And so the argument that I would argue, I would think that OpenAI and Microsoft would want to use is say, look, we took public information that's available to everybody, right? Now, here's the problem, though. What's on YouTube is available to everybody. But if you create a video on YouTube, you still have legal rights under copyright law. And so another person coming in and grabbing your video on YouTube and putting it in their own platform, that's copyright infringement. And then
right, but here's where here's where I think it gets muddy, because if you take away the argument that you can get the full articles or you can get the YouTube videos, I don't know, maybe you can. But to me, it seems like that's a pretty easy, but that's a simpler fix to say, okay, well, we'll just block it so that sort of data retrieval aspect is out of it, but it still is using that information for its sort of training purposes, right? Because the argument that they're saying, oh, well, we're a subscription-based service that now people can get the articles elsewhere. So that kills our model. Well, A, that's only if they were taking the tiered information, really. But B, it's like, if you can't say, give me the article from whatever day and then get it, then that argument kind of goes away too. So,
well, not necessarily. Let me explain what I mean by that. In copyright law, you have multiple legal rights under copyright law. One is you can stop others from copying, period. The process of scraping is copying. So when you go and you take somebody's article and pull it into your database, whatever your database does to it, whatever analysis, whatever the neural networks do, whatever manipulation of the data that's done, that is not even an issue. The second that you grabbed it, that is a copy. So that is enforceable under copyright law. Now, whether or not what other people can gain access to the full copy, or in the form of the copy that you grab is really, that's not part of the assessment, because the data has to come from somewhere. So
okay, sorry, let me just get one clarification then. If I went to a website that, let's say the New York Times, and I read an article and then I left that website, that article is probably still cached on my computer. Isn't that still a copy of it?
there's case law on that as well. So that is not it's not considered copyright infringement if what's going on is like your basic cache within your computer. It's essentially part of the process that's being utilized for you to be able to view something. It's not considered, and as far as I've seen in the latest case law, the fact that it's on your computer as cache, that part is not considered to be infringement. But if your software engine in the process of scraping is grabbing content, that is a copy. And the courts are going to
the equivalent of.
So what we're actually talking about right now is going to be fleshed out in the court.
So it'd be different if I like highlighted it all, did Control C and then Control V into Word, then I'm taking a copy.
That's making a copy. But see what Craig's talking about is, when I go onto a site, a lot of people watching this may not actually realize this, is the way your computer works, so that the next time you go to that site, it gives you access to that information faster, is that it stores some of the content for what you're seeing in what's called cache, right, within your memory of your computer. And so next time I go to that site, I may actually see things that may actually not even be on that site. It's that my cache has got what was on that site. So that shows you that it's technically making a copy by the mere fact that I'm going through and viewing different sites. So the question is, does a court of law, when you visit someone's, let's say Craig's got a site and he has a book there, and I go and I just look at the book, my computer automatically is storing stuff in cache. Can I be liable under copyright infringement for the fact that my computer automatically does something that I have nothing to do with, right? And from what I've seen, courts have not said, no, the second you look at it, the fact that your computer automatically stores it in cache, that is not considered copyright infringement. But if I created an engine which intention is to grab the content that's on the internet, the mere fact that that's the way that the technology works, is it grabs the content from the internet, that is an element of copyright infringement, which is going to be fleshed out by the courts on this very case. So I think you're going to see this very issue be decided.
So does that mean that any website anywhere, if you copy the information on that website, it's copyright infringement, or is it only specific things that are specifically have a copyright on them?
Great question. So it comes down to the essence of the copyrighted work. So I'll give you an example. I had a client who came in a number of years ago, and they created websites for dentists. That was their exclusive business. Well, all of a sudden, all these dentists had all these websites that had their content, their images, their descriptions, their illustrations. And so somebody was going around just right-clicking, copying the source code, throwing it into another website, and then just changing the heading and just tweaking things a little bit. Now, that party reached out to me and said, look, this is what we do for a living. I said, well, why don't we do this? Why don't we take your website, file for a federal registration for your website, and once we get that registration, we'll send cease and desist letters over to all these parties and say we have a federal registration. And by the way, you don't need a federal registration to enforce your rights, meaning to say to another party you're committing copyright infringement. It's just if you're going to sue them, you need a federal registration. So I said, look, let's do this right. It only takes like 3 months to get a federal registration. You already got a mess already, so let's just do this right. Got the federal registration, we sent cease and desist letters, and we said we want $2,500 for your infringement and for the legal fees associated with this. All these people stopped immediately because they know they were just copying the website. So, but let's say that the website is 20 pages and you grab one descriptive portion that arguably really has no element of creativity or originality. It's just a basic definition of the word GPT, right? Or just what does GPT stand for? And it's a basic definition that everybody knows, and it's from the dictionary, and you copy it. That's not copyright infringement. There's no element of creativity to that portion of the website. And so if somebody else goes and grabs something that it has no element of creativity and they place it into their thing, it's going to be difficult for you to enforce your legal rights against them, because your copyright has multiple portions. It needs to be original, a human being has to be an author, and it needs to be fixed. That original portion means it needs to be some element of creativity, originality. So to go back to your original question, here's a website. Somebody comes and copies one page. If that's just descriptive stuff that really has no element of creativity to it, that's like general definitions that you could find anywhere, that may not be considered copyright infringement. However, you need to be able to make that determination. So copyright comes down to the essence of the work. So if I'll give you another example, the song, you're going to know what song I'm singing by one word. Okay, one word. Now this song goes like 8 minutes long. But if I just said to everybody here, Mama, do you know what song I'm singing? Yes,
Yeah,
that's one word. Bohemian Rhapsody, one word. So if somebody grabbed that portion, Mama, and they threw that into their song, would you argue that that one word out of 8 minutes of a song is copyright infringement? Yes, because that's part of the essence of the work. So it comes down to what's the essence of the copyrighted work, and are you grabbing that? That's a long definition to try to make it simple to understand.
Even though they can't copyright the word Mama, it's the way that they sing.
Yes, come on. That's right. That's exactly right.
Also, good voice, Peter. You're full of surprises.
Yeah, that was great.
Bit of Freddie Mercury there.
I closed my eyes. I thought it was Queen.
I'd not expected that from a lawyer.
Okay, so I think then that's sort of the argument that everyone else is making, because they're not. A lot of times, you know, the arguments I see from artists, from graphics artists or writers or whatever, is that their stuff was taken with and is being used without their consent. And when you just say it like that, and you ignore the copyright law, the argument against that is that's how we all learn, and that's how we all become artists ourselves, by studying the art of those who came before us, right? If I view a whole bunch of images and then I go and I draw one that's inspired by those because that's how I learned how to do it, you're not suing me for copyright infringement, you know, unless I'm actually, you know, doing something that is like clearly somebody else's thing, right? But I learned from it, right? So, but then they're saying, okay, with AI, which is essentially doing that, it is intellectual property infringement or copyright infringement, even though it sounds like to me on the surface the same thing, right? That the AI is just going and it's learning from all that stuff and then it's creating all this thing. But I guess based on what you were just saying, the reason why it is illegal or it is breaking the law is because it is copying that stuff, which isn't allowed in the first place. Is that right?
Yeah. So you bring up multiple important issues for everybody to understand here. It shows that Craig knows what he's talking about. So first of all, styles, right? Learning and studying. Nothing wrong with learning and studying. I can learn the Picasso style, or I can learn, you know, another style, Baroque and other things like that. So I can learn styles. There's nothing wrong with styles. A style in and of itself isn't protectable. It's the fixed work itself. It comes down to the actual work itself. So if somebody takes a painting, they upload that into Midjourney, right? And let's make it very simple here so people will understand this. Somebody took the Mona Lisa, which the copyright's long expired, but let's assume that it still exists. Somebody uploads the Mona Lisa into Midjourney. First of all, that's copyright infringement because you made a copy, right? You took the image itself, you took a picture of it. Second, you took a picture of it, that's copyright infringement. Even if you bought the painting, second you take a picture of it, the person who owns the copyright to your original painting is the artist, not the person who bought the painting. So when you take the picture of that painting, that's copyright infringement. Congratulations. Now you upload it into Midjourney, right? That's now furthering the copy. Congratulations. That's a second count of copyright infringement. But let's go into detail now. So now it goes into Midjourney. and somebody says, well, I want to put a mustache on the Mona Lisa, right? That's considered a derivative work. It's a modification to the original work. So now it's taking the original work, modifying it, and giving you a result. That derivative is considered copyright infringement. So, but now let's say that instead what's happening is I'm learning the style of certain paintings, and I'm saying, take my image here and put it in the style of Picasso. That's not copyright infringement. That's just changing and transforming the style. AI can learn things and modify things based on styles. It can even write things in certain styles. That in and of itself is not considered copyright infringement. You got to look at the original work and see the similarities between the original work and the what's actually resulting from your created work. So if I said to you, somebody copies the background of the Mona Lisa, I guarantee you 95% of the people watching this have no clue what's in the background of the Mona Lisa. There's like greenery, there's water, like they have no clue, and nobody cares. That's because it's not the essence of the copyright. They care about her face and the hands. You put a Michael Jackson glove on her, they'll notice that. You change the background of the greenery, they don't care because that's not the essence of the work. So if Midjourney takes the background of the Mona Lisa and uses that background to give you a new image, that's where we should be asking questions is that considered copyright infringement? Because that's not really the essence of the original work. It's using somebody else's work, but it's not the essence of it. And now I'm taking part of that to create a new work. Is that truly copyright infringement? That's where it becomes more difficult. If the face of the Mona Lisa is on your work, that's copyright infringement. That's simple. And so the complexities in using AI and looking at the result and comparing it to the original copyrighted work, which may have been entered into their system through scraping, that's where the litigation is happening. That's where we as AI users need to be careful. And there's ways to test this. You can go on Google, you can take your image created, you can create the image search on Google to see if there's other things similar to it. You can do trademark searches. There's other things you can do to test it, to make sure it's safe. But if you're doing a major marketing campaign for a company, I wouldn't just go using some AI platform and making the result of that AI platform the head of your marketing plan without doing a check first, or at least knowing the source.
But isn't the entire image generation illegal then anyways, if it was all based on scraping stuff that they're not supposed to copy in the first place?
Well, now what we're doing is we're breaking down where's the infringement. So let's say that Midjourney, and by the way, the head of Midjourney came out and made it clear that they do copy during scraping. They did take other people's copyrighted work. There's zero question about that. And in fact, there was an interview with the CTO of OpenAI about Sora, right? And they asked her, hey, how did you get those videos? And she said, oh, it's publicly available stuff. And then the reporter said, you mean YouTube, Instagram, TikTok? And she said, well, and then she said, Facebook? It's, well, I don't think I should tell you the source. Exactly, because that stuff is other people's work, which is copyrighted work. So when we're creating things, it's important to actually know what's the source of what's created. Now, here's the thing, though. I'm a user, okay? The question is what's created, is that committing copyright infringement? Not just did Midjourney commit copyright infringement, okay? Because something that is copyrightable can go into an engine and result in something that is no longer an infringement on their copyright law, which goes back to Craig's point, which is that the thing has been modified so much, so many things have been transformed and changed that the newly created work or the newly rendered work may not be committing copyright infringement. And yes, that's true. That is possible. However, the work itself that went in means that Midjourney committed copyright infringement. The question is, does the work that you've now rendered, the image that you now have, does that image commit copyright infringement? And that's something that we, as consumers of this technology, as utilizers of AI, it's our responsibility to figure out, does it or does it not? because I can tell you as a fact, I've used Midjourney and I've come up with modifications intentionally of artwork that clearly are copyright infringement. You know, and so you just have to be careful. And I've actually used, like an example, Logo AI, and I ran through a real live example on this on one of the public speaking events that I was on recently. I ran Logo AI for everybody live. And while I was running that, I said, here, you're going to pay $59 for this AI program to create a logo for you. Let's do that. We created the logo, paid $59. I did a trademark search and committed federal trademark infringement because it used scraped images. And so the logo that we paid $59 for, you essentially paid for a lawsuit. I mean, that's hilarious. Like, you know.
Yeah.
Wow. And that's a system that's out and people can pay for right now.
Oh yeah, and if you go to their site, and you know, I'm not saying it's good or bad. I'm just saying you can test it yourself. You can go in right now and if you look at their terms and conditions on their site, it says, "Hey, we don't do trademark searches. We don't do copyright searches. You acknowledge that, and it's your job to go and do a search. However, if you copy what you get from us, you're committing copyright infringement against our own copyright," which makes no sense. I mean, as a lawyer, I look at this and I go, this is scary. This is really scary. But the fact of the matter is, they are taking images, creating logos for you that potentially can be committing trademark infringement. But it's our job as a consumer, whether you're paying for it or not, to go and do a trademark search on what's created before you start using it in interstate commerce and potentially get sued for using the result.
Wow. Yeah, so you've paid for a lawsuit. That's
yeah.
Crazy.
We did this live. Like, we did this live. Like, I'm not making, I could do this right now with all of you guys so you can see it. Like, literally created a logo, copied it, cut it out, did a Google search, found multiple companies with the logo, did a USPTO search, USPTO.gov for the very same logo, found it federally registered. So by using that in the same class for the same goods or services, you literally would be walking into a lawsuit. It's
yeah, it's buyer beware.
It is, but
yeah, no, I get it.
Just so everybody understands, I use AI every day. I'm not going to stop. It's just that I know how to use it. It's just I know which are the sites that I can use, that I'm not worried about these issues at all. It's like I do the homework. That's all. I
guess, I mean, it's good to know that, like, as a consumer, if I'm using AI and what it produces is not itself copy infringing, then I should be safe, even if that company is later found to have infringed. I guess that's the same thing as, you know, I don't know, somebody robbed a bank and then used that money to start a business. Then everybody that uses that business can't be sued later because the business was built on stolen money. But it just, I mean, we only have a few minutes left, but what I'd like to know is your take on, and of course this is very speculative, but you know, fast forward 2 years or whatever, however long it'll take to resolve all this. But where do you think that this is all going to work out?
Random, like, sporadic pain and
a
stuff.
lot of talking going on in the background. I don't know.
No.
Somebody's got, is that you, Roland? Who's talking?
Yeah, I'm sorry, that's me. I'll put myself on mute.
Yeah, a lot of talking. Okay, yeah, sorry. So the idea is that the copy, or if we speculate as to how this all gets resolved in a whenever it takes a couple of years, whatever, for these big lawsuits to get shaken out. Personally, my take on it is AI is not going away. There's too much money involved. There's the companies that are backing OpenAI or just Microsoft itself. They're too big. There's no way that this is going to just get shut down. Okay, no more AI, everybody. That's not going to happen. So how is it going to shake out? In my mind, it could go, the most likely sort of route is some kind of, like, I don't know, Spotify kind of thing, where you gotta, you know, artists get paid because they're included in the database, but then that, if it's not opt-in, I don't know how it all works out. But I don't know. What's your take? Just speculation. I'm not holding you to this, but what do you think is going to happen? How do you think this is going to shake out?
Good question. So I believe that the New York Times versus Microsoft OpenAI case is going to settle. I think this is too big. The parties that are involved are too massive. I do not believe that the New York Times wants ChatGPT to be shut down, because that is a huge potential income stream. It's a subscription-based system. They can be a resolution where OpenAI has got some kind of like paid platform. They're paying them a royalty, certain amount per year or per user or whatever the case may be. So it's a revenue stream. Shutting them down it kind of goes against their subscription-based service, even though they're losing potential revenue because of OpenAI's ChatGPT. I think they see it as a huge potential income stream, and so I don't think they want to shut them down. Is it hurting them? Yes, but I don't think they want to shut them down. I think they don't want a decision saying, all right, your database, you got to start from scratch. I don't think they want that. They want the money. And so I think this is going to settle at some point. I think within 2 years, you'll probably see the two massive parties after they see the lawyers' bills and everything. You'll see them finally come to some kind of decision. All right. Now, let's assume that it doesn't settle, which I don't think is the case. But let's assume that it doesn't settle. What could happen? You could have a situation where I've heard people talk about the Spotify resolution, where other people subscribe to or sign up and then they get royalty based on a certain activity. Here's the tricky part about this is that you're not talking about just musicians. You're talking about like artists from all sorts of different spectrums. You've got like painters, you've got musicians, you've got videographers, you've got photographs, pictures. There's so many different areas of copyright. You would essentially have to create like a holding company with registration capability for all of these different groups of creative works that are being stored in companies like Midjourney's databases, OpenAI's databases, and others. So it would be difficult to do a Spotify deal. It would be difficult to have a resolution like that. And so could a court come out and say, you know what, you need to start your database from scratch? Yes. Have courts come out and given very strong decisions that have cost industries hundreds of millions? Yes. Like a federal district court can do that. But if that decision came out, it's going up on appeal. Like it's not like, okay, in 2 years, decision comes out, boom, all the databases are shut down. No, it's going to go to appeal, and it may even go further. It could even go potentially to the Supreme Court. It'd be interesting if it ever did, but I don't think within 2 years you're going to get a decision from a court. I think more like 3-4 years you'll hear more about what potentially could play out. But I don't see a Spotify deal. It's just not. It's not easy. Like you, I agree. It's not easy to implement. There's just too many different types of artists. So
yeah, and I think rebuilding. I think that is one way that people might go. Maybe they've already started or whatever. But building, there'll probably be some, let's say, ethical AI company that comes out saying they're building theirs from scratch based on completely opt-in information, and maybe over time that will become the norm. But then it probably won't, because the cost involved in paying everybody that they copy, it will probably make the service just not price efficient for anyone using it, right? That becomes the issue too. And then how do you determine whose work was used to generate any particular response? You can't just pay everybody every time it's used. Maybe it's a flat fee situation, but you certainly can't say to the AI, when you generated this image, give me everything you used to train like every image. You can't do that, right? So yeah, I think that's
they would have to come up with. I could see something where they come up with new ingenuity to be able to determine it's just, this would be very complex, but they would have to determine percentages of usage of certain content in rendered results. So let's say I have a painting and my painting's results are just not used at all. Like it's just the results that are coming out are just almost never have anything to do with my results or with my original painting. Imagine if they could come out with a technology that actually determines, from the rendered results, what are the percentages that the content for creating that rendered result is using my content. It's just so complex to do something like that. I mean, I think people need to understand how neural networks work. Like, you're talking about millions of different things, billions, trillions of different things coming in and learning based on different patterns and, a little bit of that, a little bit of that. It's not like it says, oh, there's these two words, combine them, give a result.
Right.
There's so much transformation that's happening in the algorithms that it's not as simple as saying, hey, Roland's book 0.1%, he should get because the results is using X percentage of his content. It's so complicated. So yeah, it's not going to be an easy resolution at all. But in the meantime, they made $1 billion revenue last year, and they make a lot more this year.
Right, and that's the thing, is there's going to keep on generating revenue. The longer these court cases take to work through these issues, the harder it's going to be to shut it down. The people, the population are not going to want it to get shut down, right? When it's so ingrained in our society, when every company is using it, we're all using it as part of our daily lives, and then you get to the Supreme Court and they say, oh no, shut it all down. Nobody's going to even want that as the resolution.
Yeah, but I can tell you as a fact that courts have no problem doing that. I know federal district court judges that wouldn't blink an eye. Like, this is illegal, shut it down now. Boom, and that's it. When President Biden was allegedly calling people saying, don't go to vote tomorrow, right? That really wasn't Biden, in case anybody didn't realize that. Somebody was using AI to create, deep fakes that were using his voice and then automating that in robocalls to call all sorts of people. Well, the government acted within like 2 days. When they saw this thing coming, they passed a new law saying it's illegal to use AI to create deep fakes and then use that in robocalls. So the government has the ability to move fast when it wants to. I don't see that happening here. I don't think they're going to interfere with this. Now, you look in the European Union right now, there's laws that are being passed on AI. Like an act literally just got passed, a few weeks ago, regulating AI usage in Europe. And so you need to say, okay, well, what's going to happen over here in the US? We'll see. But as for this case right now, I think it's going to settle. I don't think you're going to get to that point where the court has to make a decision on what's going to happen to the database. I don't see that happening. So, but we'll see.
We'll see. Well, maybe we can have you back again. Unfortunately, we're running out of time, but maybe we can have you back again to see. Well, you said it's going to take years, but I mean, this is such a it feels like we've only, scraped the surface.
We really have, and I can tell you that every single week there's new things that are happening. And this is why I created ALUN. It's like the AI Legal Update Network. This is all I focus on. And the people within that network, I just tell them, hey, this is what just happened. Like, I just had a meeting last week with the Copyright Office to talk about usage of Grammarly. And has the law changed, or how's the Copyright Office dealing with that? Because that's artificial intelligence. But you can file a copyright application using Grammarly. Even though you used AI to get you a result, you can still use Grammarly and then submit that for a copyright. Well, that's use of AI. So I had a meeting with them to talk that through and say, okay, what's your logic here? How's this playing out? And, that's the kind of information I tell the people within that private network, because it takes a lot of time to keep up to date. But in any case, everybody should be aware of this stuff and watch it, because it's going to impact everybody. But I'm not going to stop using it. So.
Better to ask forgiveness than permission, I guess. Well, thank you so much, Craig. We've gone a little over the time, but I think it was absolutely worth every minute. Do you have any final questions before we ask Peter where people can find out more about his services?
I could talk on this subject for hours. This hour flew by, and there's a lot of things I didn't even get to ask. So yeah, we might have Peter back on some other time once we finish paying off and paying his legal bill for this hour that we spent. but yeah, I really, thanks a lot for coming on. It's a pleasure to talk to you again, and yeah, let us know where we can find you.
Yeah, absolutely. So if people would like to gain more information about myself or like some of the programs that I'm running, which are trying to keep people up to speed on these important legal issues, but simplifying it so everybody can understand it, just go to peternieves.com. It's www.peternieves.com. And there you can just sign up to continuously be made up to speed on different things. I've got like an AI ebook that's there as well. It gives you the top 3 legal concerns for AI bot users. You can grab that there as well. I'm just trying to keep everybody up to speed. So if you go to peternieves.com, so the last name is N as in Nancy, IEVES, then you'll be able to stay up to speed on this.
Perfect.
Oh, that is brilliant. Well, we'll make sure to put a link to your website down below in the description. And if anybody's listening to this and has really, really enjoyed it, I'll tell you what you should do. You should scroll down there, find that link, and leave a comment for Peter to say how much you appreciated all the wisdom that he shared with us today. And I think, yeah, we didn't have to pay a penny for it, which is... and also, while you're down there, if you haven't already, hit that like button and show how much you appreciated Peter's wisdom, and hit that subscribe button if you haven't done already. And we'll be back next week with a brand new episode of Fully Booked. So until then, thank you very much and goodbye.